Hello, everyone, and welcome to Baseline Tech Talk, your go to podcast for navigating the evolving intersection of AI, security, and ethics. Today, I'm thrilled to introduce our guest, Vibhav Mithal, an esteemed AI and intellectual property rights lawyer. As an associate partner at Anand and Anand, Vibhav blends over a decade of experience in IPR litigation with a focused expertise in AI and data protection. He has been part of critical legal milestones in India, including the country's first AI and personality rights case, as well as its first software patent. With prestigious accolades such as being named a rising star by Managing IP from 2022 to 2024, and co authoring NASSCOM's Developer Playbook for Responsible AI, which aligns with the India AI mission, Vibhav is a pivotal voice shaping responsible AI governance in India and internationally. Before we dive into our conversation, let me set the scene for today's journey. Navigating AI regulation is like steering a ship through a stormy sea. Technology surges forward like roaring waves, while governance tries to chart a steady course. In today's discussion, we'll start with a landmark case that blends AI and celebrity rights, move on to ownership of AI generated works, examine the legal gray areas surrounding training data, and conclude with a broader look at proactive AI governance and voluntary frameworks. So, with that in mind, welcome Vibhav. It's an absolute pleasure to have you with us today.
Thanks a lot, Marybelle. It's an extreme honor and a pleasure, and I'm really looking forward to this conversation.
Thank you. Vibhav, you provided strategic input and AI expertise in India's landmark personality rights case involving actor Anil Kapoor. From that perspective, what implications do you think this case holds for AI generated content and the protection of celebrity rights, especially as these issues are gaining now more global relevance?
Thank you. The Anil Kapoor case was different in terms of the timing in which it happened, right? So we have to. It's important to get into the timing aspect of it. ChatGPT came out in November 2022. Jan 23 was about when we had started seeing some sort of litigations that started around generative AI. Unlike the traditional AI copyright training data disputes that we see today, and the first one which is filed in India probably it was last year, Anil Kapoor took place 2 years back almost, right? Almost 2.5 years back, 2 years back. And it was different for the reason that we were talking about a tool generating an output that was violating someone's personality rights. Personality rights is when you have a famous individual and you are taking its voice, name, likeness, image, persona. My role here was just like you framed, is it was just to sort of bring in the lawsuit had multiple other aspects. The team at Anand and Nayak are handling those different aspects. I sort of just came in the initial part to sort of give the of how do we tackle the AI component of it, right? And the main point that we want and why this was different from others cases, that's the first part, was because we realized that when you have a tool that is generating someone's likeness and persona, it's obvious that the person that is using the tool, and the person here is an end user, someone who would be entering a prompt on the tool, right? Not necessarily AI developer company or any of those stuff. We're talking about a wrongdoer who is a common person who is using your AI tool as it's accessible to us, and it is entering a prompt in the tool, and by entering such a prompt, it's likely that in order to get an output that violates someone's personality rights, it is obvious, or it's not obvious, but it is likely, and one can make an assumption that a prompt has been entered that violates their rights. Something about the famous personalities aspect was entered into the tool to be able to generate that output that violated that personality rights, that in famous personalities personality rights, right? So that's the key differentiator and the important aspect on the from the AI lens, that it was at the intersection of AI and personality rights, not at the intersection in that sense AI and copyright that we usually see. It happened 2 years, almost 2 years ago, and and just about 8 months after generative AI became popular through ChatGPT. What are the implications? The implications are that, at the end of the day, personalities, famous personalities, also have to have legal recourse, right? They also have their own sort of set of rights, and we sort of created a window by doing this, by filing this case. We created a window on how these types of rights can be protected. And after the Anil Kapoor case, we've done a couple of other litigations on the aspects of AI and personality rights. So the extent AI impacts a famous person's rights, we have a recourse through, and because this conversation is going to move to governance as well, we have a mechanism through existing solutions, existing laws, and existing court structures. And I think that's very important to emphasize.
Thank you, Vibhav. I do think that that's a powerful illustration a bit of how legal systems are starting to catch up more or less with digital realities. So building on that, let's move into the legal complexities of copyright in AI-generated works, since we touched on that, especially given how current frameworks remain deeply tied to human authorship. So there's significant debate over who should own the rights to AI-generated works, whether it's the developer, the user, or even the AI itself. From your experience, where do you stand on this, and how do you see copyright laws evolving to keep pace with AI innovations?
Absolutely. This is now, I would like to contextualize. This question is about IP creation to an AI tool, right? In that context, and you mentioned three really good important perspectives, Marybelle, which is developer, user, and AI system itself. Now let me take them one by one. In First, let's take the easiest one: AI system. AI system by itself is not a legal person as on date in any jurisdiction. That, from a technological lens, ties to the concept of have we reached artificial general intelligence? The short answer is we have not. Whether we will reach there or not, it's an open question, but as of the date of recording of this podcast, we are not at AGI, and we don't have any legal precedent of AI being recognized as a legal person. So AI system by itself being recognized for IP registration is not part of the conversation as of now. That leaves us with developer and user. Now, when we talk about developer, in my mind, I'm phrasing that as, say, a person, a company that has built an AI tool. Now, there are different AI tools in the market. And let's take the simplest example. We could have a large language model, and you could fine tune a large language model, with the large language model being a text generating model like ChatGPT. We could have a large multimodal model, which would not generate text but generate images, videos, and in that sense their output is videos and images, and basically not text, right? We have both these kind of models. Now you could have a scenario where people would build applications on top of these large language models or large multimodal models. In that scenario, the copyright IP ownership aspect is an aspect of legal analysis, because if I am someone as a user, uh, building on top of it, maybe I'm another company building on top of a Gen AI platform, then the terms of use become relevant in terms of the IP aspects, right? The terms of use of those Gen AI platforms by themselves, and that requires, again, AI governance, including legal analysis. When we come to the, but now let's come to the last one, user, which is the one that we have some clarity on, right? So there we would get into the question that let's take an end user, and back inside a case we had this. Again, I'll go back to 2023. We had the Zaria of the Dawn case, right, in the US Copyright Office. This is March 2023. Once again, in terms of our timelines, we'll be really answering this at the time when ChatGPT became popular in November 22. In March 23, we have this scenario where we had a person who built a comic book. The comic book entered prompts in an AI tool. The manner in which the tool generated output was random in nature. The US Copyright Office analyzed the that AI tool relevant there, and found that the prompts that the individual entered, because of the output being random in nature, even though there was creative output that was being created, the copyright protection would only go to the human aspects of that comic book and not to the AI generated images of that comic book, because of the fact that there is a requirement of originality from a copyright perspective. Originality means it has to originate from you as a human author. And in that scenario, the AI generated output was not original enough to be origin for it to be say that it belonged to the human. And like we just discussed shortly back, that it does not vest with AI. So it's AI. It's again a contextual question. You have to have origin to the human. It has to be original in nature, and it has to owe its origin to the human. Does that mean can I not use the AI tool? For sure, you must use it if it augments your work. If you know how to use it, and if you're able to use the prompt and the tool is operating in a particular manner that allows your creativity as a human being in helping create that output. But as of right now, the traceability of the human element to be able to make the legal requirement of original work of human authorship gets satisfied. And once again, that's where we stand. There are and again, it'll be a contextual analysis every time we engage in it. But that's the nub of where the crux of where the law stands as on date. And it's difficult to give a complete answer in the abstract. It will involve what prompt you're entering, why you're creating that output, how much did the AI tool actually help you, how much of your human input was coming in as a creator, and how was the tool operating.
No, I understand. I think context contingent factors always play a role, and I think the situation really underscores just how much AI is stretching the boundaries of traditional copyright assumptions. So, one of the most contentious issues in AI right now is the use of copyrighted material during the training phase, often without the creator's consent. And we've seen a growing number of lawsuits from authors and artists as a result. In past interviews, you've referred to this dilemma as the AI copyright trap. Could you unpack what you mean by that? And could you explain how copyright violations are emerging during this phase, especially as we move from generative to agentic AI?
Excellent question. This is, I mean, this is the flow is brilliant because the previous question was about IP creation. Now we've moved to IP infringement. In this context, the copyright paradox is so the paradox was this, that if assume I'm a creator, and I'm not going to get into the details of what type of creator I am. There are multiple suits on this aspect, and they're still pending in court. But let's assume I'm a creator. The only way I know that some of my rights have been violated is by analyzing the output of the tool. If the output, let's assume, is verbatim reproducing my artistic style, or is verbatim reproducing my phrases of the book that I've authored, or well, text from the book that I've authored, right? That gives me an indication that the from the output that my rights have been violated, possibly because of the fact that at the training stage, the AI tool learned on some of the materials that belong to me, for which no consent or authorization, well, no authorization was taken from me for training, and based only on the output am I realizing my rights have been violated, and therefore I'm sort of reverse engineering from that process backwards. Right now, there are two things that are missing in this analysis. One is that the entire conversation about the prior to some of the suits being filed for violation of training data, majority of the understanding of AI copyright violations initially was being seen from the output state, where the aspect stays at the training aspect, right? So we've been talking about how do I ethically, properly, legally, responsibly train data at the outset. This is the main issue that arises here, and my conversation on paradox was that while I look at the output, I ignore the fact that the problem starts at the training stage, right? And therefore, it's a twofold conversation. One is, which was also discussed in the World Intellectual Property Organization forum that we moderated this year, was about how do I can create a copyright infrastructure of training data. How do I correctly collect training data which respects rights of copyright owners and encourage innovation? And what are those mechanisms? One could be to collecting societies. One could be talking about getting individual licenses. You could approach music labels. You could approach uh, different mass owners of copyrighted content in order to train your models. And we've seen some of those deals happen at the training stage, right? But the in sort of to contextualize this more for your audience, I want to just pin this down to a couple of points. When we're looking at the AI and copyright intersection, we have to understand, are we talking about AI violation at the output stage, or are we talking about AI violation at the training stage? If we're talking about AI violation at the training stage, we have to be very clear how the AI model was trained and what mechanisms could have been done differently at the training aspect. Both are different stages, right? And if I am alleging a violation at the training stage, then it is important for me to also understand how exactly is my copyrighted content getting stored in the model, used by the model, and then being retrieved by the model at the time of creation of output. This technical process has to be clearly spelled out. And this is the exact point that I wanted to emphasize, that these cases are not just about, yes, it is about AI and copyright law. It is about protecting creators. It's about providing them adequate compensation without authorization. But this is also as much about being able to communicate to court sensibly, correctly, with technical support, how the copyrighted content in form of data went to the model, what did the model do on that, how did it store it, how did it store it, reproduce it if at all, and then retrieve it at output, and does that entire process actually call for infringement, right? That's why these cases are important and the hope with so many cases around is that we will get clarity on this, and this will tie um, to our conversation on governance, because these questions are both legal and technical in nature. We cannot answer them in the absence of either perspective.
Of course. Yeah, I mean, I think it captures really the crux of the issue here, where you see these legal gray zones that kind of collide with real ethical concerns. To wrap up, Vibhav, let's zoom out a bit. You've worked on the NASCOM Developers Playbook for Responsible AI, which sets out voluntary governance frameworks aligned with the India AI mission. And in a landscape often dominated by legal uncertainty, how important do you think such voluntary frameworks are, especially in guiding companies proactively, I would say, on issues like copyright, bias, and accountability?
I think extremely important. I think it's critical to understand. First of all, AI governance is broader than current laws. AI governance includes current laws, intellectual property laws, consumer protection laws, data protection laws. Uh, Maybe if you're operating in a sector like the fintech space, then something from what that relevant regulator may have passed in the context of AI. You have current laws. Then you have good practices. You could have voluntary frameworks, like we spoke about developers playbook for responsible AI, and I'll just come to that in a minute. But we have a framework from the Telecommunication Engineering Center in India on bias assessment. We have another framework from Telecommunication Engineering Center in India, which is part of the government of India, on I think robustness, to assess the robustness. We also have a voluntary sort of guideline from the Indian Council of Medical Research in the healthcare space. What's the point? And then what is the playbook? The developers playbook for responsible AI, which is now aligned with the safe and trusted AI pillar, which is one of the 7 pillars of the India AI mission, which is one of India's which is the India's main AI sort of mission that's taking forward the AI development in the country, to which this playbook that we co-authored is sort of aligned with. Why is it different? Because it goes down from the AI governance perspective, this law class good practice perspective. It goes down to the downstream person working in the organization, which is the technical person. The word developer here does not mean the concept of developer as we understand in the EU AI Act. It does not mean a provider in the EU AI Act. It just means a technical person working in an organization, and that organization by itself could be an AI provider, it could be an AI deployer, that does not matter. The point here is we have identified, we've conceptualized, we've addressed the developer, we have identified for him the or him or her, for the person, the relevant person, the actionable steps to implement responsible AI. Responsible AI are principles. We've low, gotten into detail, reduced the abstraction of the principles, and identified actionable steps that you can take, which steps emanate from law, emanate from good practices, may emanate from other sources when there are certain sort of guidance aspect also given, and we've conceptualized, so we've given them actionable steps. Point 2. Point 3, we have making it different from what existed in India at that point of time is that we have conceptualized an AI life cycle. We've got 4 stages of AI life cycle. Then we have divided the playbook into 3 AI types. Discriminative AI, example, healthcare applications, pattern recognition tool of AI, where you learn on different types of data, you identify a particular type of data, whether it could be maybe trained on X-rays showing lung cancer, and the AI model now can detect lung cancer by analyzing an X-ray. Generative AI, Chat GPT, LLMs, and then AI application built on top of generative AI and discriminative AI. So we have 3 types of AI: discriminative AI, generative AI, and AI applications. And then across the 4 life cycles, so that's 12 silos, and each silo you've given identifiable actionable steps built on law and law plus approach, more on the lines of AI governance. These steps for anyone that is working. See, the main call out and why I say this is important is because when I'm working in the AI space, it is extremely important for me to be legally compliant, of course, but also to sort of move forward with the right guardrails. Because if I'm waiting for a moment that I will have all of AI in one law, that moment may or may not arrive depending on which jurisdiction you are in. But my assumption is that you would like to do business in a global market, and you would have to build in guardrails that either adhere to the market that you're looking to get into, or you're looking to, in the current market that you're in, you're going to build those guardrails so that you're at least compliant and safe. Because in the end of the day, the last point I want to say on this point and why voluntary frameworks are important, and this also ties back to sort of the AI audit criteria that's being drafted for humanity, where I'm with, and which is also one of the sort of leaders in AI audits and AI governance, is the fact that AI is a socio-technical system. And I want to kind of end sort of this question on this point that our humanity, our rights, our freedoms are deeply embedded with these systems. And if I'm not proactive enough as a business or as anyone using an AI system, I will there might be an adverse impact if I'm a business on my reputation, if I'm an individual on how I'm perceived as using those tools. So that's the reason why I think it's important for us to look at this topic in this broad sense.
No, absolutely. I think responsible governance doesn't need to wait for legislation, so I completely agree with you on that. Vibhav, thank you for unpacking the layered relationship between AI and intellectual property, from the enforceability of personal rights in AI generated content to the human centered nature of copyright law and unresolved tensions at the training stage. Today's conversation shows us just how complex this space already is. As your work with the NASCOM playbook illustrates, companies can't afford to wait for perfect regulation. Governance needs to start now, both in policy and practice. That brings us to the end of today's episode of Baseline Tech Talk. A special thank you again to our distinguished guest Vibhav Mithal for helping us decode the intricate relationship between AI and copyright law. Stay tuned as we continue to unpack the key forces shaping AI's role in today's world, right here where technology meets ethics and security. Thanks for listening, and until next time, this is Marybelle Cherfan signing off.